We are live.
In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place at the town hall at 7:30 p.m. on Wednesday, June 5th, 2024.
Corey Biller,
Here.
Michael Cohen,
Here.
Deborah Nevis, Frank Segmundi,
Here.
Sue Johnson Shawn, Srini Vijay,
Here.
David Cosgrove,
Here.
Gaston Halbert,
Here.
Beth Soul.
Here. Great. Our first order of business is the approval of the minutes from April 3rd, 2024. Eileen, did you receive any comments?
I did not.
I had one question, Frank, maybe you recall. It said that you called to adjourn and I seconded, but I feel like I usually make a motion to adjourn. Do you have any specific recollection?
I think I
You
probably
think-
seconded it.
Yeah.
Okay.
So I think if we could swap, I mean, it's truly minor, but I noticed that. I said, Frank doesn't usually say like, can we adjourn? Okay. So with that change, I will move to approve the minutes. Do we have a second?
Second.
Okay, all in favor? Aye. Any opposed?
I'm here with theirs.
And assume many who are not in attendance would abstain. Okay, meeting minutes with that one minor change from April 3rd, 2024 are approved. We have multiple items of business tonight. The first one is bylaws, and if I could allow you to introduce yourself, council, and I'm sorry for not doing that as we opened the meeting.
No problem. My name's John DeLuca. I'm Steve Warner's associate. Steve and I sat down, we walked through these bylaws, we looked over some of the comments that board members made. Nothing major or significant. So if we want to go through, I think maybe the most expeditious way is just go page by page, and I can ask the board if they have any comments on each item. And then as they arise, we could address those comments.
That is fine. I'm not sure that all members of the board have it in front of us.
Okay.
So I would say maybe we should begin kind of a comment by comment, like you going through the comments that you've received.
Sure.
And then if members have any additional comments, I think some people may have digital versions of it.
Sure.
And I will just ask for the record, everybody, you feel free to pull up the PDF of the bylaws, but please refrain from kind of Googling or internet searching while in the context of our meeting or emailing, etc. Thanks. So yes, the bylaws, which just to back up for context for everybody, we recognized at one of our first meetings of the year, Steve had mentioned as new council, that we didn't have kind of current active bylaws. It's something that each board is recommended to have by the municipal land use law. It's not a requirement.
No, it's
but
not.
It's a recommendation.
Right, and it's a strong recommendation. I think bylaws, the real purpose they serve is when a board doesn't know what the proper procedure is or what to do, or a member of the public or an applicant, then they can refer to the bylaws, which are set forth as rules and regulations. But if there's a minor deviation here or there from a bylaws, it's not a capital offense, but it is a good roadmap as to how the board functions.
Great, thanks. And so Stephen had sent us some samples from other municipalities. We gave some feedback saying, okay, why don't you go ahead and draft us some for Millburn, following pretty much the same template of recommended sections. And now with that intro, it would be great if you want to go through the comments received, and then if folks have any others, maybe we can do it after.
Sure.
That's okay.
I appreciate that. I'll go through Gaston's comments first. His are on the top of my pile. So Gaston had a number of comments. His first comment was related to Rule 1:1-3. This is location, the office location of hearings. So you mentioned maybe broadcasting live, and just updating that applications could be kept at the board office and online. I think that's a great idea. It would probably require a little bit of administrative work to set up a live broadcast.
It is, we are.
So you are broadcasting live, so
Yes.
it's just a matter of indicating that, okay, so we'll amend that accordingly, that makes perfect sense. So it could be something along the lines of, unless the board shall always determine meetings took place, meeting dates below. And then I would say, after one of these sentences, just and broadcast live online.
Mhm.
And then, at the borough office and on the internet. On the borough website, or
For the records.
on the website.
Yeah, for the,
Yeah,
sure,
township website.
absolutely.
So just, if we're gonna say and, there might be unless other technical difficulties or something, because I wouldn't want it to be absolute.
That's right.
But maybe, we'll endeavor to our best degree.
Right, and where, when available. That's true, because we've
Yeah.
been some boards who have been unable to get the technology to work for whatever reason, we wouldn't want that.
All right, so subject to technological availability. Okay. So those are your comments as to the broadcast. Then in Rule 1:2-1, you've noted he or she and proposed perhaps more inclusive language. And if that's your intention, it just thinking through it logically and into the future, I think the most inclusive language you could really include, and I'll just read the portion of the sentence that's relevant. This is referring to a candidate receiving the majority of the vote of the regular membership of the planning board shall be deemed elected to the office for which the vote was taken and shall serve for 1 year until, and then rather than he or she, you'd say the candidate is reelected or a successor shall take office.
Yeah, and like that, I guess that's only one instance of it, so wherever we have that, are we able to reformulate it to where it does, it's more inclusive?
Yeah, and I can do a search through and make sure that we're rather than pigeonholing ourselves into one or the other or anything else.
Perfect.
We'll make it general and inclusive. And then I think you had one more comment about where was it highlighted? Oh, this is about eligibility for voting. So, if somebody, let's say an applicant has subsequent hearings and a board member missed one hearing, but then comes to the next hearing where a vote ultimately occurs. As you all probably know, that member has to certify that they reviewed the transcript or watched a video and are up to date on the hearing. So as a practical matter, during the meeting, I think it's okay for you to say, yes, I swear, you could even do it under oath, but ultimately there must be a written record of that certification. So if for the sake of streamlining that process, during a meeting, you can say, yes, I swear, I reviewed the transcript, I watched the video, I'm up to date on the hearings. But then, shortly thereafter, maybe by the time a resolution is adopted, you have to have a certification in writing for the sake of the record. Especially if it's a controversial application where somebody is trying to, attack the legitimacy of the board's approval or denial. You want that certification in writing.
And we're comfortable
What
with that.
number is that?
That's 2:2-4. So right now it states certifies in writing, and that language should stay. And just as a practical matter, you can do it orally in the moment, but then it has to be followed up with a written record.
Okay.
So I think those were all of Gaston's comments. If we go over to Dave's comments. So special committees, this is Rule 1:2-5. Dave, I believe you mentioned, maybe making it a little bit more democratic rather than the chair appointing the members, the board collectively appointing the members.
That's what I was thinking, yeah.
Yeah, there's no law or regulation that prevents that. Customarily, it is the chair. So that's really the only comment from council in that regard. But if the board were inclined to, make it so that the board votes on the committee, it's the board's prerogative to do so. My own 2 cents on this is, generally committees are by interest or, obligation, necessity, and to just streamline that, the chair appoints and has a discussion with the board members as to who makes most sense to sit on a committee. But, you know, if the board is inclined to operate otherwise and have everybody vote on every committee, then that's perfectly legal. So I guess that would invite comment from the board. What is your take on that issue?
I think it's safer to do it, have the board
Yeah.
vote as a whole, because, and don't take this the wrong way, but if there was some issue where the chair had a minority view, that could really slant who ended up on that committee.
Sure.
Yeah, one way to do it, sort of, to help ease administration, so the board doesn't have to take a vote every time, is to say by appointment of the chair unless otherwise, you know,
So the chair's appointment could be vetoed?
Yeah.
Okay.
that way, you know, you have a simplified process for all the regular kind of normal appointments.
Right, most committees are, do we have a few
Yeah, most
volunteers and
committees
we get a
have
few
people already got,
volunteers,
there
I
are
guess.
a twist to actually volunteer. That way,
Sure.
you don't have to roll call them every time. Ultimately.
I think that makes sense. So you could add a veto provision in the event that a majority of the board deems, you know, the chair's appointment inappropriate or void. They could.
Unless otherwise,
Yeah.
what's the word? Disapproved by a majority of the board, so.
Well, I don't think we should limit it so that the nomination has to come from the chair. I think if anyone on the board wants to nominate, then they should be able to do so, to nominate someone for some.
For a committee, usually we volunteer, is typically people want to serve, you just raise their hands or, you know, send a message. It depends if some we do in person, some we announced it, but not everybody has been present, so we say, you know, we'll circulate it, we'll let everybody know should they want to, but yeah, it's fine. So including some sort of veto provision I guess you mentioned something different, that doesn't have to, that's a nomination as opposed to the what if you don't like who the chair recommends.
Yeah, I definitely think there should be a veto provision.
Okay. So we could do a veto provision, and is there any other mechanism? You know, you mentioned that what's most common is board members volunteer for these positions.
Mhm.
So, you know, if there's a lack of volunteers, I suppose then it would have to be by nomination. So beyond the veto provision, does anybody on the board find it necessary to add another provision for nominations or anything like that? Or do you feel the veto provision would be
Well, maybe we should specifically have language in there that says committee members are, you know, able to volunteer their interest.
Okay.
That way, because right now, if you read it, it literally says, you know, appointed by the chair. And so even though in practice, they ask for volunteers, we should enshrine that into the document.
Okay, so I think in the preceding sentence, before the chair shall appoint, I could say, members of the board may volunteer, and then the chair shall appoint, and then at the end, a veto provision, you know, subject to the approval of a majority of the board members.
That works.
This may be getting too complicated or conspiratorial, but what if there's like a block who volunteers who have a particular view and they all volunteer to be on that committee, but other board members, like how do we handle, you know what I mean, if there's a.
Sure, I mean, as
Is
with
it-
any committee, something gets sent back to the board for the board to vote. So I guess if there is a majority block in any way, almost regardless of.
That's exactly where
So
my
you
thought
handle
was
it when
going.
the report comes back rather than the formation of the committee.
So yeah, it would have to be a board, it's ultimately a board decision, just, you know, like we've had numbers of subcommittees on the, you know, elements of the master plan and, you know, decisions on attorneys and whatnot, and professionals. It's ultimately the board, you know, the committee might make a recommendation, but the board can choose to, you know, agree with it or vote differently, I guess. So,
And I would say those blocks, they do naturally occur. You know, there's nothing conspiratorial about that, as you mentioned. And if that block happens to be a majority, that's the majority. That's how the board functions. So I wouldn't be too terribly concerned about that. I mean, I'm sure there are instances where boards get contentious, but there's turnover and people have to find a way to work together ultimately. So I'll work on rewriting that particular provision and get that out to your review. Also, I should have said this at the outset, even though the agenda indicates that this is for discussion and adoption, there's no requirement that this is adopted tonight. And given, some of these revisions, I would assume the board would want another opportunity to look at.
Yeah.
So we can discuss this tonight, and we'll get a draft out to you probably sometime early next week, so that you can review it again in advance of next meeting, with a target on adopting, hopefully. Okay, so the next comment was Rule 1:3-6, order of business. David, believe you added public comment?
Yeah,
I think-
I was thinking we'd add a public comment period.
Yeah, and so, no, we've, council has no comment on that, I think that makes sense. Okay, appointment of alternate to serve on case. So this kind of happens organically. This is rule 1:4-2. So this rule describes instances where a board member is disqualified or conflicted out of a particular application or matter, and then an alternate has to serve in their place. That happens just orally on the record. There's no need to enshrine it in writing. I don't even think it's necessary to explicitly state that somebody was conflicted out and an alternate sat in during in the resolution. That'll be reflected in the voting roll at the end of the resolution. So just simply stating it at the beginning of the hearing is perfectly fine. Mentioning such board member is conflicted out or disqualified, and alternate member so and so will be serving in their place.
Okay. I mean, my thought on that one really was that when I look at how we function, right? If someone's out, that meaning just doesn't show up because they're, sick or whatever it is, or someone gets disqualified, it's really Eileen kind of when you do the vote, you kind of, I mean, there's never, I don't care, one way or the other, but there's not it's not that formal where Beth says,
For
You
the
know,
record, David will be acting.
Michael's
so-
missing, so,
Yeah.
so therefore, but it makes no difference to me. It was just a matter of, we function one way, and this is kind of changing it.
Okay,
So,
so
right,
makes
because
sense.
whereas we typically don't make the announcement of it or document it. Or appoint, we don't typically say. And for the purpose,
I mean, if it's a better practice to do it, then that's fine too. Then
Right, and because we don't, if we have less than a full board, we don't announce.
I that's all I was
Voting
thinking,
members
yeah.
tonight. Kind of don't micromanage the process. So is your suggestion, we might just not need this member here? Or-
So, I mean, in reading the provision, I don't think any change to this language is really necessary based on everything we've discussed here. I think you just kind of do it as you've been doing it.
Yeah.
And what you described and how you've been doing it is perfectly consistent.
Yes,
Uh,
we
with-
just don't make the announcement.
Yeah, not inconsistent. I've had that conversation with a few boards. What's the difference between consistent and not inconsistent? Which I'm sure we'll get to when we discuss the ordinances. Okay, so moving on to Rule 1:4-5, this is rights and privileges. So no, actually, an alternate member is legally not permitted to serve as chair or vice chair. It has to be a member.
good enough, thanks.
Okay. So this was a comment, so your next comment was on Rule 2:1-5, continuances. You said, let's have a discussion about how the board can, how we can protect the board on continuances where an applicant will not consent and/or it's a large application, we need more time. So as a practical matter, first of all, I think this is very rare. And then secondly, if there's an applicant who, I don't know, not hostile, but maybe is acting, as an adversary to the board, which isn't terribly uncommon. And it's you're running out of time to make a decision. If the board ultimately determines we have not heard enough to grant this application, we want to hear more, we want to have another hearing, and the applicant will not consent, then the board is perfectly within its rights to deny the application without prejudice. meaning you issue a denial, telling the applicant, if you want to come back and allow us more time, you can come back. But at this time, we're denying the application. The only instance where it would be very, very specific circumstance where I would caution a board from doing that is if, this is an application that has been going on for, 10, 12, maybe more hearings. And
Thank you. It's the motion sensor.
yeah, I deal with that all the time. It's a very rare circumstance where the board would be in a position where they want more hearings and the applicant is justified in not consenting. So, and when that instance comes up, your board attorney would be able to advise you on that and say, we should have a vote tonight, or it's not wise to have a vote tonight, and here's why. It's really a case-by-case basis. But in terms of protecting the board on continuances, the mechanism to do that is a dismissal without prejudice, or denial without prejudice, I should say. So denying the application, and that's because, the applicant's not consenting to another 30 days or another 45 days, whatever it might be, based on the board's scheduling. Okay, Mr. Applicant, then we will have to deny your application without prejudice.
Is there language that could be added on the hypothetical you were giving about, it's the 12th hearing, right?
Mm-hmm.
And let's say the applicant is not cooperative. Is there language we can add that gives us more protection on that?
So, we could add explicit language saying that at the board's discretion, the board may make a motion to deny without prejudice. Put that in there explicitly.
You have that right anyway. Okay.
You have that right anyway. And again, because it's such a particular case-by-case basis, you want to think of every possible hypothetical, but you'll get bogged down thinking, oh, well, what if this happens? What if you really try to? So that's why on a case-by-case basis, you really, you need to consult your board attorney and say, what can we do here? And I've been, I was speaking with the chair before the meeting about my experience being an applicant's attorney, and I've been involved in applications where it has gone on for many, many hearings, and there's an objector involved, and there's outcry from the public, and then my client says, okay, I don't consent to a further extension. The application gets denied, and unfortunately, in those situations, it ends up in litigation, but it was going to end up there anyway because you had an objector, you had public outcry. So those are the times where you really have to consult with the board attorney and figure out, what is the appropriate legal thing to do here, not only to protect the board but to protect the public.
And did you speak to this? Did you speak about this with Mr. Warner or? Maybe?
Absolutely, I spoke about all these
Yeah.
comments with
Okay, I was
Mr.
going to say, or
Warner.
maybe after,
His-
following this discussion. if you
yeah,
have any follow-up.
His specific, this is his writing, is
Oh, okay.
deny with prejudice.
Okay, so, thanks.
Thank you.
So, so what you wouldn't do is allow a default appeal, was really his point in talking to me. You don't just allow a default appeal to occur, you deny without prejudice, and then they have the opportunity to come back if they want to go down that road. Okay, so your next comment is on Rule 2:1-7, testimony from board employed and other expert witness. Okay, so you said, let's discuss adding language that members can discount in whole or in part evidence not found credible. So if you read further down, that language is actually in there. It says the board shall not be bound to accept the testimony of any expert. Where there's conflicting testimony of experts, the board shall decide which to accept. These rules are not construed as requiring expert testimony in all instances to sustain a board finding. So that first sentence I read is not bound to accept the testimony of any expert is kind of, I think, what you're getting at, where you can discount in whole or in part testimony or evidence not found credible, unless there's something else beyond that you were.
That's kind of it. What I'm trying to capture there is a scenario where the applicant has a planner testify, as an example. And the board members, obviously the majority, right? But the board members find the testimony of the planner not to be credible, period. Even though we don't have our planner get up and say the opposite or something else. I wanted to be clear that the board could just say, you know what, I just don't believe this guy at all, and they haven't sustained anything, we're gonna deny the application, but protect the board if we did that.
Yeah, the board shall not be bound to accept the testimony of any expert. So,
Maybe in a whole or in part, something like that, but that's what I'm trying to protect against.
so in whole or in part, and then I guess regardless of any counter testimony or
Yeah.
counter expert.
I don't know if we need that last part, but
Okay.
that's up to you guys. So. Thank you.
No problem. And then you also said, let's add language that bans cell phones, electronics during testimony. So what exactly did you mean by that?
An example that happened here a while ago was a witness was testifying and someone was texting that person answers to the questions
Okay.
while the testimony was live.
Yeah.
And I wanted to try to put that in the rules so that, we have something to say, you know what, you're not allowed to do that.
Yeah.
Of course, another way to fight that.
I mean, I think it goes without saying, but
Yeah,
it's.
but you can ask the person, are you receiving text? Yes. Is it about the subject matter? Yes. Okay, fine. I don't deem you to be credible, and thank you. I'll deny.
Right. Well, that should go for the board members as well, right? Like, if the board is receiving texts. with
Yeah, and I
questions
think
to
I've
ask,
heard that on both sides, that board members shouldn't be receiving stuff either.
Right.
Yeah.
Yeah,
Should all be
it,
just present.
it definitely goes both ways. It's not who wants to be a millionaire. There's no call a phone friend, no
Yeah.
lifeline.
Call for, yeah, there you go.
But sometimes we have people who are reading from the phone or maybe they're.
Right, and just like tonight, just how I said, feel free to access it, but please don't, use other electronic means.
Yeah,
I
and-
guess that would be the.
And Dave's comment, it did say, limited to communication, because that's another thing. When I first was reading a comment, my one alarm bell goes off. You can't generally ban electronics because it's a public hearing. People have a right to record if they want to.
For communication.
But for communication
Yeah,
purposes, for a witness, yeah, there's no problem about adding that in. And then same comment regarding requiring a writing versus oral on the record.
I think you kind of answered that, but
Okay.
that was more like, the practice has always been, it's oral versus writing,
Moving right along. Okay, so now we move to Rule 2:3-3, inability to make a verbatim record. So Dave suggested, let's discuss this. What occurs when the parties don't agree, or there's a dispute as to the agreed statement of fact? Also, who determines if time is a factor, or if there is a dispute about time being a factor? Is it cleaner just to adjourn? So this is a rule about if there's a problem making a permanent record, so a problem obtaining a transcript or a video, and then there's an appeal to Superior Court, the parties will come together and agree on a statement of facts to be supplied to the reviewing body, so it would be a judge or the appellate division.
Regarding an application? This is all with
This-
regards to an application?
This is in regards to
We
an
always have a
appeal
stenographer.
or further review. Yeah, so I think we're covered with the video broadcast, the stenographer. I find it hard to believe that you would not be able to make a verbatim record. And in the event that you cannot make a verbatim record, what ultimately will happen will be dictated by that reviewing body. That reviewing body will, in this case, I'm imagining a judge, will say, okay, I want the facts from the applicant or the objector, and I want the facts from the board, and then I will decide what facts are, what's credible and what's not credible based on whatever record is available. So that would ultimately be kind of taken out of the board's hands or bylaws. But again, as mentioned, there's a court reporter, the tape, the video, all of the above should not create a circumstance where you can't create a verbatim record. And then you mentioned in your comment, is it cleaner just to adjourn? You know, if you know, let's say there's a power outage or thing, I would think that there would be an adjournment anyway. So,
All right,
so I think that that's adequately addressed in the language there. And then disqualification generally, this is Rule 3:1-1. So this is the test for when members need to be disqualified, and this language is right from a New Jersey Supreme Court case. So I don't think it's necessary or appropriate to change that language since that comes right from the Supreme Court standard. And then really the general rule is if you're in doubt, step out. If you're not sure, if you have a conflict or should be disqualified, then you should. So in all, you know, if it's a neighbor, it's somebody I know, it's, you know, I have a business relation, step out.
I had one comment
Sure.
above that, and maybe I missed it
Oh,
on
I
what
might
I
have
sent
missed
to you, but on the, so everyone, it's 2:3-9, and it's the final paragraph, second sentence. You have the responsibility and authority for enforcement, et cetera, remains with the Township of Millburn, Engineering Department, Post-Resolution Approval Committee. I don't know that we have that, but maybe I'm wrong. Is it, we don't, not that anyone's ever heard of this. Eileen, maybe?
I don't even know.
Page 13, at least on my printout, top of the page,
Yeah, if you go to part 3, it's the last sentence before.
above part 3,
Before
that's an
part
easy
three.
way to do it, yep. It's the end of that sentence, just says, Township of Millburn, and then Engineering Department, Post-Resolution Approval.
So is your comment essentially that there is no post?
I don't think there is, but I'll
There's
defer
no
to you.
actual committee, it's basically, if there's any conditions of approval that are in the resolution, you know, prior to the issuance of a CO, or the applicant shall submit
Right,
ABC
revise plan to the
before
forester or
permit shall
something,
be
yeah.
issued. That's
So
typically
any other
looked at by
provisions.
either
It's
me
more of a
and
case
your
by
mom.
case basis.
Yeah, I mean, but there's no specific post-resolution approval committee.
I mean,
Just
I'm
say,
fine
and
with the
any other,
condition, I
you
just
know,
want to get the
conditional,
right name,
yeah.
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 Names.
No, that's good catch if there's no committee, but
So we can eliminate post-resolution approval committee, and we could say, rather than the committee, we could say, rather than say the board, because the board
Right.
means the body acting together, you could say board members and their professionals.
yeah, I think it's like, and any other professionals who
Yeah.
who may, you know, be
Yeah.
whose conditional approval may be required or something, right? Like,
Maybe not the board, because
Not
we don't,
Well,
Any
yeah.
other- We don't
I was
play a
saying-
role
I
in
was
that at
saying
all, as far as I know,
Not the
right?
board,
Yeah.
but, yeah.
other municipal professionals, I guess.
thank you.
That's good, thanks, Jamie. Was that all your comments?
That's all
I
I
think that was it.
I have just one thing which I just noticed.
Okay.
It is in section 1:3.3-1, it says if the regular meeting falls on a legal holiday, such meeting shall be held on the Thursday of the following week. That just does
We
not
tend to
happen.
not do that.
If it falls on a holiday,
We tend
we
to.
don't have a meeting.
Well, we approve the calendar, yeah.
We approve it at the beginning of the year. So we don't typically,
Okay, so that should be changed.
yeah, I think that can just,
We just take that out, yeah, because we usually approve the calendar, and then if we need, we schedule special
Right.
meetings, you know, as needed.
That was 1-3,
1:3-1, third line.
it falls on the
That's it, we generally don't schedule meetings on a legal holiday.
Yeah, like
We wouldn't have
we normally would meet on the 19th, but we're closed on the 19th, so we're not having a meeting.
So you just adjourn to the next regularly scheduled meeting?
Right. When
We schedule the
them at the
calendar
beginning of the year.
Right, right.
To
Yeah,
take into
holidays.
account.
Oh, okay.
So we
All right.
just don't.
So, I guess, how do you avoid the holidays? Do you put
We
it
wouldn't
on?
have, we might not have a
We
meeting.
don't
Just not have a meeting.
Thanksgiving
Okay.
week, we might not have it, yeah, some months have two, some months have one,
So we'll just say that, no meeting will be scheduled on a
legal
legal
holiday.
holiday.
Sure.
Okay.
That's appropriate.
All right. Any other comments from everybody?
I have a couple.
Sure.
So in 114, the organization meeting, I don't think that's the policy we followed this year, where it says that the attorney shall be conducted in the presence of the board attorney who was appointed for and served through the preceding calendar year. We chose not to do that
Right.
in the interest of being polite,
Mhm,
right?
mhm, that's correct.
So I think,
Although generally, I think the contract does run through, like,
right, but we held a meeting without him.
that is correct.
So that gets sticky when you're replacing the attorney.
Mm-hmm.
Maybe
So you could
review
say-
that. We
yeah.
should- Yeah, we should.
Yeah,
review.
we'll come up with some other language, like unless otherwise determined by.
The board or board professionals. Yeah. Thanks.
Okay.
Did you have a?
Yeah, then I have three, in the second one, in 1.16, where we say the board attorney, this has to be somebody other than the township attorney. So also was unclear, for a time, the board attorney was also the town's fair share housing attorney, representing the township.
Mhm.
So under this provision, would that not have been allowed?
No, the township attorney is a distinct post, and that a fair housing attorney would be.
Is separate, so
It's
that
separate,
is
yeah.
okay to have, okay. Okay,
Well, would it be better if we make sure that they're not the same person?
Yeah, what's
It
the
didn't work out
practice?
so great
Some
for us
towns
last
have it
time.
as the same, some towns don't.
Yeah, it's
I'd
town.
rather have that as separate, meaning prohibited, so to
Yeah.
speak.
I agree.
well, it's hard to do that because you have two different groups of people approving who the attorney is. So who got there first? I mean,
Right,
you know.
yeah. I
Well,
don't know.
the township would approve, the TC would approve the special counsel for fair share, right? Township would approve, TC would approve their own counsel, and then we approve our own counsel.
If you're hiring at the first meeting of the year. you
Yeah,
may
yeah,
not,
yeah.
Yeah, and it would really be on the attorney to understand that, okay, I can't have multiple posts here in this town. And they would have to prioritize which one of those entities would they prefer to serve.
If our bylaws say it can't happen.
Right.
Which, okay.
I don't know if we need to write that into the bylaws or each board should decide. I might say, hey, we already have this professional working for that board. We don't want, so as to not preclude yourself.
I just don't know how that happened. I honestly don't know how it happened last
Well,
time.
I know it happens in other towns,
So,
like where people will serve
where
on the
the
same.
planning board attorney is the
Is the
special. See, I'd rather say that, I'd rather we have a policy.
Or the
that
municipal
not-
attorney is their fair share attorney, however. Sometimes
We are doing today.
Mhm.
Yeah, that's true today. So
Yeah,
now we have that double.
That's a
Yeah.
conflict, yeah, so why is one permitted and not another? I just don't know that.
Well, the difference.
I see a
difference is-
distinction between the TC having the special counsel being the same and us having it.
They work for the same board versus two different boards.
So I guess my question is, are you suggesting that we eliminate or add, Is it board shall only appoint?
Well, it's me making it more, this just says it can't be the township attorney, that's why I asked, but I guess David's saying it can't be the
The special.
special fair share housing attorney either, because they report to reporting to two different boards.
Right, so other than the township attorney and a specially appointed, special
Well,
appointed.
I think the better way to do it is to say, no other attorney serving as a municipal land use attorney for any other board, because we also have the HBC attorney, which is a municipal land use attorney.
Okay, that's a good point.
So we ought to have those all be separate.
Is that how everybody is? that you all.
What's the concern? I'm not saying I disagree
Yeah.
or agree, I'm just.
Yeah, I just want to make sure we have a consensus.
The concern, well, one, we don't want to have a repeat of a situation that we had over the past few years that didn't work out very well for our town, number one. Number two, I think it's important to have different voices on the municipal, different legal voices on the different municipal land use boards. If they're the same person, you run the risk of two boards then potentially getting, incorrect or biased advice. Whereas, having them separate gives them checks and balances. So for instance, when the TC has, a change to zoning laws, it comes to the planning board for review. If they had the same attorneys, well, that could bias that review process.
And that would extend, I guess, to the fair share housing attorney, because then we have to, some of the fair share housing ordinances have to come here as well. So that's where that conflict would also could come up, I guess. And I don't feel strong on that, I was just asking the
I'm just
question.
wondering, is that an actual conflict, maybe that is conflict from an attorney in that situation, that they would have to recuse themselves, or?
No, because the interests would not be in conflict, the interests would technically be aligned, but I'm inclined to agree with you in terms of, for the sake of protecting the town and its constituents, you do want that diversity of opinion.
Just one practical question, and this is for those of you who looked into when we were looking to hire a new attorney. These are very specialized areas of the law. How much choice do we have? Like, the one thing I don't want to do is back ourselves into a corner where we're like, oh, well, the planning board essentially has to go with this attorney because, this attorney, that attorney has the special master, and this one is the historical, and this one is zoning, and so like it backs us into a corner that we only have the choice of two firms or one firm. I just don't know.
I mean, you could also say, if you're concerned about that, based on a majority vote of the board members, you can waive this provision.
We're also I'm only talking our town too. I don't know if that's answering your question.
No, even, I
It's
think,
not that somebody represents a special counsel for Livingston. And there, I don't know if that's.
I know,
Those are what we're worried
what I'm hearing in what everyone was saying is like, well, we have this committee and special master and this one, and so I'm starting to hear like, all right, we're gonna need like 4 different firms representing, which is fine if we have the option of 4 quality firms. I just don't wanna back us into the corner where, but if we have the option to waive, then.
Yeah, then you can avoid that concern.
Then if we feel that there is equality and we have to, the risks outweigh the rewards, then we can waive,
Yeah, I'd be comfortable with that.
The last bit is just also kind of minor, but under the board engineer, she only comes when there are applications on the agenda. And this makes it seem like she has to come all the time.
Well, it says, as instructed by the board. So
Okay,
who shall
that's-
attend meetings of the board and committees of the board as instructed by the board.
Okay, that's the, okay.
and similarly, Eileen will sometimes send a message to me saying, do we need Eric tonight, if we don't have an application, I'll say, no, it's fine, yeah.
I just didn't want to make
Yeah, I
it look like
appreciate
she had
that.
to come.
Right, why have
You know,
her
why does
come?
she need to be here?
Actually, before we go too far from that other point, I think if we're gonna say the majority can override, it should be a supermajority that's
Okay.
required to override with the attorney.
What's the supermajority of the planning board? I know we just haven't used that, but
Yeah,
I'm not
I know,
familiar
I mean,
with
of the
that term.
zoning board, it would be a minimum of 5 votes, so you could do that here.
That is the majority, 5 and 9. You
5
agree?
and 9.
Yeah,
So a supermajority
Would
would
be
be
6.
6 of 9,
I do 6 and 9.
6 or 7 of 9. You could, whatever 2/3 would work out to be.
Is there any other provisions that we require a supermajority?
I've never,
Not for a planning board that I'm aware of.
What is the concern that we would require a supermajority as opposed to a majority?
the attorney.
Because the
representing
majority-
board.
The majority would
but-
be picking the attorney in the first place, right?
Yeah.
So it, in essence, would defeat the purpose of saying we would, want separate attorneys if by default, whoever the attorney the majority picked was then, permitted to go past that check. So the supermajority gives it that little bit extra of a check. I personally would say it should require 7 of the 9, but maybe if 6 of the 9, that's fine, but it should be more than a simple majority.
It's not pitching the attorney, it's only.
It's overriding this
Overriding
conflict.
the rule, right.
Yeah. All right, does anyone else have any comments on any particular rules?
Amy, did you have any others? I know you mentioned.
No, I just, that one just my eye on.
Thank you.
We don't meet on Thursday.
We don't do that.
We don't.
All right.
Okay, so then you would take those revisions, incorporate
Yes.
them. Will you send us a black line version? like
Yes,
that?
I will.
Okay.
Yep.
Fantastic. So we'll distribute that and then hopefully be in position to take action at our next meeting. Thank
Perfect,
you very much.
my pleasure.
Okay. That said, we'll move on. And if anybody has any follow-up comments or questions, please reach out directly to, you can ask Eileen for the, forward an email via you to.
Yeah, comments are welcome up
To
until the
Steve.
point that they're adopted, and
Exactly.
even beyond, because you'll adopt them again if you need to.
Sure, okay. Just in case anybody has any
Right.
final reads. Okay, let's move on to, we have 3 ordinances tonight. We also received planners reports. Let's begin with ordinance 267824, which is the proposed ordinance amendment, DRZ 425 checklists. Graham, we have you here tonight. If you want to recap your letter.
Sure, absolutely. So good evening, Madam Chair, members of the board. Graham Petto here this evening as the board planner. Yes, I did provide a consistency review of the ordinance 2678-24, application forms and checklists. I'll kind of go through this in a high level because there's a lot of content here, but I don't want to belabor too much. Everybody had the benefit to read. But for the benefit of the public and those watching, I'll be sure to cover the bases. So the township currently maintains 2 separate tracks and sets of procedures for applications, submissions to the planning board and zoning board at this time. Each board maintains their own set of application forms and checklists with separate submission requirements. This can create problems for comprehensive and prompt review should an application be transferred jurisdictionally from the planning board to the zoning board or vice versa. Having been deemed complete before the planning board under their checklist, while additional materials may be required by the zoning board or again vice versa, which are not submitted. Further, the zoning board submission requirements are tailored to its most common application type, which are site plan exempt residential variance applications. Submission requirements are not organized by application type, so an application may be subject to extraneous submission requirements or otherwise not need to provide materials warranted by the application scope. And submission requirements to the planning board are much more detailed and expansive than what are required at the zoning board, including greater detail in architectural plans, signage package, sustainability checklists, environmental impact statement, circulation, landscape, and facilities plans. But it's important to note that the zoning board does have jurisdiction to review site plans just like you all do. When the site plan application contains a D variance, the zoning board has jurisdiction and they really should be reviewing to the level of a site plan review as you all do here at the planning board. At both boards, various site plan requirements specified in Article 5 of the DRC are either not included in the current checklist or only partially so, creating a disconnect between what the township wants to see in its application filings and what applicants and the board see on the application forms. References to the required application fees and escrows are not referenced on the application forms, requiring applicants to locate the relevant sections within the DRZ or reach out to the board secretary to conduct calculations, request required fees from the applicant, and kind of go through that process. So in sum, this is a process that's designed to create some standardization for the application for development, the checklist, so that both boards have the benefit of seeing the full set of materials, understanding the requirements that are within the ordinance, so that applicants know what those submission requirements are, know where to look for the lighting standards, know where to look for the landscaping standards, in accordance with the checklist. So that's kind of the summary of what the ordinance is doing to address these issues. Now, regarding the relationships to the master plan, the ordinance advances the following objective and recommendation of the master plan, which is the first one listed here on page M1, to promote clear, user-friendly, and transparent application review and public hearing processes for development proposals and applications, so as to ensure an effective and well-publicized mechanisms for both for residents to report on quality of life issues and code violations. As an update to a consolidation of the planning and zoning board's application forms and checklist, the ordinance does not represent a policy change, but directly addresses the above this recommendation by limiting the forms needed by applicants and consolidating all submissions and fee requirements of the DRZ into one common streamlined application form and checklist to resolve those disjointed issues that were highlighted. So any questions or clarifications there?
I have one question. Is there a concern, and maybe it's even more for the zoning side than the planning side, but that this is going to result in like more waiver requests, like for checklist items? I know that we sometimes get them, on our applications, but if you're saying we have a more stringent requirement than zoning. And
So-
now,
That's a great question. And I think circling back to the idea of the site plan exempt residential applications in
Yeah.
particular, what we've done in structuring the checklist is we've listed the set of requirements by application type. So single-family residential applications have a much shorter list of requirements to submit. As you scale up to larger site plan applications, obviously those lists become more comprehensive. So we've tailored the application form and checklist to respond to that exact question. Yes.
Well, first of all, I think you should remove my name and first floor, because I don't really think my name needs to be on the application, because then when I leave, you've got to adopt another, you know what I'm
Sure.
saying? So I really, Township of Mosley, 375 Lombard Avenue, Milburn, New Jersey, and maybe just the phone number.
Just board secretary.
Yeah, oh, that's fine as well.
Sure.
My other concern is you have the date filed, which is fine.
Mhm.
But you only have the completeness determination due by. Now, there's no spot to put the date the application was deemed complete, and there's no place for either Martha's signature or my signature, deeming it complete.
Okay,
So I think that should probably be put somewhere.
sure. Mhm. Those two items, yes. Just making it.
Great. Any other questions? Okay, thank you. Now, again, our action tonight would be not inconsistent or inconsistent with the master plan, and then we could provide comments back to Christine, as well as the TC. So, I think we would, if we were gonna determine it not inconsistent, we would return it with those comments.
Yes.
Exactly. Okay. Does anybody want to take action?
And move that it is not inconsistent with the master plan.
Please.
I'll second.
Okay, great.
And David, you will be voting tonight in the absence of.
So, sorry.
You'll be voting on this. Corey Biller,
Yes.
Michael Cohen,
Yes.
Deborah Nevis,
Yes.
Frank Sagamundi,
Yes.
Sujata Shan.
Yes.
I'm sorry,
Yes.
Srini Vijay.
Yes.
David Cosgrove,
Yes.
Gaston Halbert,
Yes.
that's all.
Yes, thank you. Our second ordinance for discussions, 267924, proposed ordinance amendment to DRZ 301, 606, and 607. Graham, if you would similarly walk us through your memo.
Absolutely. So again, this ordinance is a product of the Zoning Code Examination Subcommittee, which has been working on various amendments to existing definitions and incorporation of new definitions to resolve identified issues in this in zoning outcomes, vagueness of terms, and missing definitions of operative terms in the DRZ. Following the prior definitions ordinance, which we just reviewed previously, which I think had a second reading last night at the TC 2674-24. This ordinance before you this evening for referral advances several more definitional issues of priority for the efficient operation of the DRZ. The ordinance includes the following amendments to section 301.1, which is the words and phrases defined section of the DRZ. First, it amends the existing definition of the floor area ratio non-residential to apply to multifamily uses as well. Further employing FAR as an intensity control, it includes basements that meet the definition of gross leasable area within the FAR calculation. So if a business is using the basement level for its gross leasable space for operation storage of materials, that should be counted as FAR space or floor that's being used for that use operation. Second, it amends the prevailing front yard setback definition to resolve some issues that have been identified in deployment of the revision that was made last year, as Ms. David has raised with us, and the zoning board has also highlighted. Specifically, adjacent properties included within the prevailing calculation are no longer limited to those on the same block, and adds clarifying language concerning applicability of variance relief for building additions where the existing front yard setback is greater than which is permitted. So for buildings that are further set back beyond the maximum line, if they want to do a second floor, they're too far back. So kind of created an odd situation. In addition, a former exemptive note has now been reincorporated into the R3, 4, 5, 6, and 7 districts, which permits variance-free minor modifications to existing non-conforming stairs or stoops to add a roof and support column. This is a limited, there was previously provision in the prior definition here that allowed a small covering. I believe it was 6 feet wide. I don't have the ordinance language in front of me.
6 feet wide on either side and no more than 4 feet.
No more than 4 feet out to allow just at least a cover over the front entry door. So that could be exempt from the prevailing front yard setback calculation. That's created a lot of issues.
So it would be potentially more than 4 feet or something.
No, it was mistakenly taken out.
They're just putting it
They're
back
just
in.
putting it back.
Right, this is just restoring that exemption. So a homeowner seeking to just do a small 4 foot by 6 foot covering over their front door, so that for some shelter from the weather, from the elements, they don't need to go for a variance because it's a prevailing front yard setback issue at this time. The next one, we add a definition for shopping center for multi-tenant commercial developments. This use is defined elsewhere in the ordinance, but does not have a defined term associated with it. The use is listed under applicable parking standards and loading standards, but we don't have a definition of what a shopping center is. We need to create that and constitute that within the ordinance. We've also amending the definition for front, side, and rear yards to remove the loophole that created voids on properties where portions of the property may not fall within a defined yard. So, for example, the front yard was to the nearest corner, but if you had kind of an undulating front of a house, what was that? From the nearest corner to the street was a front, but if you had a further point back, what was that space? Was that a front yard? It wasn't clearly articulated how that was treated, so that's clarified. Clarifies, and then finally it clarifies the language and loading requirements table of section 607.1 to employ defined terms for retail uses where the undefined retail store is presently used. So shifting gears to the relationships to the master plan, this ordinance advances the following objectives and recommendations of the master plan re-examination and update. The first is goal 1, objective 1.01, to protect the character of established residential neighborhoods and encourage land use and development at an appropriate scale and density. And 2, again, to promote clear, user-friendly, transparent application review and public hearing processes for development proposals and applications so as to ensure an effective and well-publicized mechanisms for residents to report quality of life issues and code violations. The ordinance revises and adds definitions to reflect and improve recent zoning amendments, as well as resolving longstanding gaps or loopholes that have been present in the DRZ definitions or lack thereof to promote clear and purposeful functioning of DRZ. More specifically, the amendments relating to the front yard setback, including the front yard prevailing setback, seek to improve ease of use for applicants as they apply prevailing methodology against the surrounding existing character, while also removing impediments for minor home improvements for residents.
Can I ask you, but also possibly address it to Aileen as the secretary? So when I picked up, when I was reading it, I saw the remove, it looked like it was a strike through on the point closest to the corner or whatever was the point closest to the street. But then you said it clarifies it so they know, so you would know what to use. And I was almost thinking, well, if you're not going to use the closest corner, then what are you using?
Using the whole house.
The whole
And so
house.
rather than just, it used to say to the nearest point. So we had situations where the house was either not perfectly square to the lot.
Yeah.
And so they were like, well, here's the closest point. Well, so you had areas.
If you draw a line
where
across and the house
it
was
didn't
askew,
really- You had like parts of the front and side that didn't fit into the front yard or.
But you feel that the zoning ordinance now includes
Yeah.
the appropriate methodology to pick whatever the point is going to be. Okay, so long, because I read it as like, oh my gosh, this is making it more confusing. But as long as you feel that you would know what to do with that.
Yeah, there's another one too we discussed during the subcommittee. So if you have a round house
Ah.
without any corners, still a problem.
That's a good point.
Or something. Yeah, it didn't quite encompass everything, but it did solve it.
Great, thank you.
Could you just, for my sanity, because I'm
Yes.
still, prevailing front yard setback, I understand what you added, that if it's beyond the maximum, you're allowed, you can do a second floor, but then it says, so long as the distance of the closest point of the building to the front property line is not made greater than the existing non-conforming condition. I completely do not understand what that would
so
be.
so they can go in line with the existing,
Okay,
an addition that's in line, they can't come forward,
oh, they can't.
right? So you can't cantilever over,
So,
so it has to be in line with the existing.
but even though because the in, if whatever they're adding is beyond the maximum.
Correct.
So that.
Sort of grandfather.
Yes.
Okay, thank you.
Can you say to the positive so that someone reading it, like, meaning saying that
Made those
Yeah, exactly, that you made those the existing.
I'll explain to them.
Okay. But to
Eileen
your
makes it
earlier
up.
point, I think to your
It's
earlier
not
point,
you.
what if it's not you?
They're on their own.
That's what he's trying
That's what I was
to.
Yeah, well, I mean, in my case, like, I kind of inherited, and like, when Tom did this before, I'm like, I don't even know what that means. He's like, well, that means, so it is, but I don't plan on being here to instruct anybody when it's their turn. I'm just gonna go.
That's what I was saying,
So,
so
you might wanna-
sort of think about saying it in a positive, it might be easier for the next person.
Well, I think, so I mean, if I
That's
can.
what I thought it
yeah.
meant, but I'm thinking, is that what?
So it just says, expansions or modifications to existing principal structures whose existing front yard setback is greater than the permitted maximum, so setback beyond the maximum setback, shall not require variance relief of the maximum front yard setback, so long as the distance to the closest point of the building to the front property line is not made greater than the existing non-conforming condition. So it's basically saying that.
Can you say is the same as the non-conforming condition?
I mean, I guess we could say is, instead of is not made greater, you're saying is in line with the existing non-conforming condition? Is that what you're seeking to change?
Or less, yeah, is in line or less. I'm just looking at a way to solve for, if Eileen didn't understand, and, yeah, she's been doing this a long time and she's pretty good at it, we're doing, the intent is, under the master plan to make things more clear, so I wanna just make sure we're actually being clear.
I'm trying to figure it out. It's hard because it's coming forward rather than going back. It's kind of-
Yeah, it's hard to think
it's hard
about,
to
right?
think,
Yeah, I think that it may not be something that we can solve like in this moment, but perhaps your recommendation to the TC could be to clarify that last portion of the sentence. So for clarity, and we can do that and then present the revision back to the
We can't
TC.
do it here.
We will do
We're
it.
gonna be able to do it.
No, well,
Not always do.
Eileen's, like,
yeah,
let her reflect on
we
it.
can coordinate on that and provide a recommendation pursuant to this body's
Right.
recommendation
Have a
back to the
brainstorming
TC.
session when we're not all
Yes.
staring at you, that's fine.
Chocolate.
Zoning text is not an easy.
Any other
thing to-
questions from folks on to Graham's points? Okay, I will move to recommend ordinance 267924 is not inconsistent with the master plan and recommend possible rewording on the reference to the setback, just to clarify the language.
second,
Corey Miller,
yes.
Michael Cohen.
Yes.
Deborah Nevis.
Yes.
Frank Sacamandi.
Yes.
Sujata Shan.
Yes.
Srini Vijay.
Yes.
David Cosgrove.
Yes.
Gaston Halbert.
Yes.
Beth Zoll.
Yes. Okay, and our final order of business tonight is ordinance 268024, proposed ordinance amendment to DRZ 804, which is the designation of historic landmarks and historic districts,
Mhm.
and talked about sort of procedurally how that
Sure,
happens.
sure. Just kind of a summary of this ordinance that's before you this evening as well. The DRZ outlines the procedures for designation of historic sites and historic districts in section 804.3. Following recent historic preservation efforts, such as the adoption of the new historic preservation element in August 2023 by this body, and subsequent designations, this section of the code has received an additional look by the Zoning Code Examination Subcommittee, and amendments were identified to enhance clarity and transparency of the process prescribed by the municipal land use law. In particular, regarding procedure for filing of a protest against a historic nomination in coordination with the HPC attorney and chair and members of the Zoning Code Examination Subcommittee, some additional necessary amendments were identified during the drafting process and are presented within this ordinance. So the ordinance amends section 804.3, as I mentioned, with the following clarifications and corrections. The first is that it specifies that the HPC review the nomination received either by the prepared either by the Township Committee, Planning Board, or the HPC, which are the entities that may prepare a nomination report. The HPC is to review that nomination report for completeness to ensure it has all the components of the required submission prior to scheduling of the public hearing, the notice public hearing process. Second, it clarifies the language around procedural requirements during the HPC hearing and subsequent HPC report to the Township Committee, recommending historic designation. Third, it incorporates references to municipal land use law requirements for submission of a protest petition against the proposed historic designations, including the required number of signatures, submission procedures, and impacts on the final designation subject to filed protest. Fourth, it corrects the maximum time period for the planning board review upon referral from the Township Committee from 60 days down to 35 days, so that is now consistent with the municipal land use law requirement of 35 days. Revises language for greater specificity regarding requirements for incorporation of historic designations into township records. Adds clarifying clause regarding the usage of the term landmark, which is employed throughout Article 8 of the DRZ, inconsistent with the definitions within the MLUL, which has a specific definition for what a landmark is. And then finally, other clarifying amendments to language within the section. There's a couple of other tweaks to kind of smooth things out. So regarding the relationships to the master plan for this ordinance, it advances objectives and recommendations of the master plan as follows. Goal 1, objective 1.01, to protect the character of established residential neighborhoods and encourage land use and development at appropriate scales and densities. Number 2, which we've talked about, promote clear, user-friendly, and transparent application review and public hearing processes for development proposals and applications, so as to ensure an effective and well-publicized mechanism for residents to report quality of life issues and code violations. And the third one is to the statement to monitor recent tear downs and new construction in single-family districts to determine whether additional zoning modifications are necessary to protect such neighborhood character. Following the adoption in August 2023 of the township's new historic preservation element of the master plan, the township seeks to conduct a transparent public process for consideration of historic district designations that provides property owners with a full understanding of the designation process.
Questions? I just have one question. I know
Sure.
you mentioned you went from the 60 to 35 days to be consistent with the MLUL. Are boards allowed to give themselves more time, or is it like if there's a discrepancy, do you defer to the MLUL?
That's probably more of a legal question than
Right, because it had
I
given
don't
us,
know.
I guess, just maybe in case meetings are out of sync or something.
perhaps, yeah.
You know, giving yourself this limited or more limited window.
Right, yeah. So I
Wasn't
mean,
a huge
yeah, really,
issue,
it needs to just be
yeah.
consistent because it's the same as an ordinance change. So
Right.
like, these ordinances before
So
you,
just-
there's that time period of review.
Okay.
This would function in the same way for
Thanks.
consistency review or inconsistency review.
I think it should be stated, the zoning code examination subcommittee that looked at this and worked on this actually had recommended against the inclusion of the specific details with regards to the protest provision. That board felt that it would be better to simply reference the municipal land use law as opposed to having the detail in there. One of the reasons for that was if municipal land use law changes, we then have to go back and change this ordinance. Some members of the township committee really wanted that protest provision in there, based on events that transpired last year. I disagree with that. I don't think it should be in there. I know there might be others here that feel that way, but I just wanted to put that on the record. That I don't think it's a good idea to detail in the ordinance how to defeat the ordinance. That I don't think will help advance the historic element of the master plan from coming to fruition.
I tend to agree with you for a different reason, mainly the first one you cited, which is every time, then you have to stay on top of the ordinance and you have to change your regulations every time it changes. I just don't know that we have, as a planning board, what we can do about it, so.
Well, in answer to that question, because I had raised that with you, I guess, right?
Mhm.
And with Graham, because I was concerned about things getting out of sync. And what we were supposed to say, although I don't believe it does, that where it lists the ordinance and then says as amended, then that would keep it.
No, I know, and look, I draft policies all the time in my real job. But that requires somebody, yes, technically it would be in compliance that way, but then
But
you're
I
still
mean,
listing.
it says that if there is a discrepancy, the state statute overrides.
Yeah, but you're still giving people specific information that might have been overridden, and so they'd have to know to go to the statute, as opposed to if you don't put it in, then they automatically go to the statute.
I felt that way as well. That it shouldn't be in there.
I just don't know that it makes it inconsistent or not.
I don't know that makes it not inconsistent, and it sounds like it has been discussed at the TC already, so we certainly could include it in our report, make that
Yeah, I mean,
recommendation back.
maybe include it as a note if this board feels that, what Mr. Biller said is correct, that it would be better to just simply say, protest provisions as per, we didn't even cite the part of the municipal land use.
Right.
I mean, I think tying it to the planning board is if the intent is to make it more clear, I think adding that detail arguably could make it less clear in the future.
So maybe that's something we could report back.
I guess how often is that changing in the MLU?
Yeah, just for the benefit of the board, so it's NJSA 40:55D-63 is the provision, and this protest provision is actually applicable to all zoning ordinance adoptions. So there is a protest provision for, essentially historic designations are a zoning overlay. The protest process is applicable to all zoning ordinances, so there is a protest option for all zoning amendments. So this is broadly applicable to a lot of things, not just a unique HPC specific protest provision. And we haven't seen this changed in quite some time, so.
And yet we haven't included this protest provision in our other.
It has not been included in this local ordinance, but I have seen it included in other Historic Preservation Commission ordinances, or I shouldn't say Historic Preservation ordinances in other communities.
I don't have an issue referencing the statute and saying as amended, but referencing specificity outlined in the statute just seems to be confusing.
Well, we could make a recommendation back. I mean, I don't know that calling out that provision, I think it's kind of like what you're saying, may or may not be the difference in being not inconsistent or inconsistent with the master plan, but you're right. I mean, if we're trying to seek for clarity, maybe just referencing the state statute so that okay. I think it would.
I'll just say, it's not necessarily my view, but I think this source from the fact of the neighborhood that was protesting the designation, which is now likely to be tabled. It's pretty obvious that they had 20%, 20% of, they submitted they hit the requirements of the protest provision, but to this day, they still don't know that they have hit that. So the reason the language was there was for transparency, so that they would know that.
I don't think they actually received 20% in written form, and the municipal
I'd abstain
code
with that,
requires it.
I don't know that they have that, but given the number of people that showed up at the meetings, I'm sure, and all the emails we got, I'm sure if they knew they had to go after it, they would.
If you cite the statute and write as amended in it, then couldn't they just Google the
Yeah,
statute?
yeah.
Yes.
Yeah.
Yes.
Okay. I mean, I think we're all saying that everybody should have the ability to act as they want to, but it's just that how much are we baking it into the ordinance versus recommending a
How
reference
easy
in
are
the
we making it
ordinance?
for them to know what they're looking for?
I see. Yeah, making it right, giving them a point to go search. Okay. Thank you.
Sure, no problem.
Is that staying in?
It's up to them.
So we have to take action now.
Okay.
I would make a motion that ordinance 268024 is not inconsistent with the master plan, but regarding the, it's not protest.
The protest provision.
It's protest provision, thank you. Referencing the municipal land use law section as opposed to including that entire provision, which could become inconsistent down the road, which could necessitate more updates
And cause confusion.
and cause confusion. So not inconsistent with the master plan, consider removal of the protest provision with just a reference to the MLU.
Right now, it's both.
Right, but just including the reference. So that's my motion.
Second.
Thank you, Deborah.
Corey Biller,
Yes.
Michael Cohen,
Yes.
Deborah Nevis,
Yes.
Frank Sagamonte,
Yes.
Sudrata Sean,
No.
Srini Vijay,
Yes.
David Cosgrove,
Yes.
Gaston Halbert,
Yes.
Beth Zoll.
Yes. Okay, thank you. Our next scheduled meeting is Wednesday, July 17th at 7:30. I move to adjourn. Oh, I'm sorry, Gaston.
If I may, just a question, we're halfway through the year, and I wanted to just ask the board if anybody has any concerns or anything that is not needed to be, or not required to be discussed in public, if we need to have a closed session, if anybody wants to talk about anything, just to open it up. Everybody okay? All right, thank you. Sorry to interrupt.
No, I appreciate that. Thank you. Okay, that's it.
Say when the meeting is again?
Wednesday, July
Oh,
17th.
July. I thought you said June and that's.
No, the next
Right.
meeting in June is, falls on the Juneteenth
Right,
holiday.
Right, okay.
July 17th, and then July is July 4th holiday. It's a mess. Okay, I move to adjourn. Do we have a second?
Second.
All in favor?
Aye.
Aye. Good night.
Thanks.
Next meeting is when?
July 17th.
July 17th.
July 4th, I thought I said.
No, I'll be in Montreal.